institution is concerned, its sole object and the purpose is to administer justice and administer justice according to the Constitution and rule of law. If there is public confidence in administration of the justice through efficient performance and early disposal of the cases with the cooperation of the lawyers and district judiciary, then we can satisfy ourselves and we can say with confidence that the people or the general public for whom this institution is working day and night is performing well. The most important issue which the public litigant is facing is in respect of backlog and pendency. Essentially, it is not a new issue or the problem which this district judiciary or any district judiciary in the country or the Supreme Court or High Court is facing. It has remained a problem of great concern for the last many centuries. A good number of efforts have gone into the process of removing the complexities of the procedure by adopting for disposal of cases. Always undue advantage has been taken of these technical and procedural complexities of the judicial system. Such legal principles and the procedures are meant to prevent the miscarriage of justice and guard against unfair dispensation of justice. Shakespeare, in his historical play, Hamlet said, and I quote, "For who would bear the whips and the scorns of time, the oppressor's wrong, the proud man contumely, the pangs of the despot's love, the law's delay." Similarly, Louis Law, Director, Columbia University, while addressing the Senate Judicial Committee, New Year 1964, said, "Remember that delay in the courts has a history that reaches past Shakespeare to Hammurabi, and no doubt past him to his ancient ancestors." Early disposal of the cases is not only our problem, it is also an issue of both developed and developing countries. According to a report, in India, there are almost 30 million pending cases in different courts. But India is a large country, thus the ratio of pendency is higher as compared to Pakistan. This is due to difference in population ratio between the two countries. But developing countries are continuously striving for reduction of delays. In Pakistan also, many commissions and committees have been established to resolve this issue. There were about 4 committees or the commission in the Pakistan constituted from time to time in order to overcome this problem. The views of the members of the bars are also invited from time to time in order to solve this issue. And the same was with the commission, who had invited the members of the bar and had obtained their opinions and thereafter had made recommendations. And in pursuance of those recommendations, certain procedural changes in the laws were also recorded, both in civil and the criminal. And after the amendment, again the efforts were made to ensure the expeditious disposal of the cases. Number of cases pending in the higher as compared to High Courts and Supreme Court. I may point out that as far as ordinary litigant is concerned, he has first of all to approach to the to the district judiciary, and thereafter the number of the High Court or the Supreme Court comes. Therefore, the total pressure always remains upon the district judiciary for the purpose of disposal of the cases. The annual survey after the launch of the National Judicial Policy revealed that all over the country 90% cases are pending before the district courts and 10% are pending before the Supreme Court and High Courts. Although 31 lakhs cases were decided in 1 year since implementation of the National Judicial Policy in June 2009. However, 26 lakh new cases were registered during the said period. This is in addition to the old backlog of cases pending adjudication. Many complaints regarding quick disposal have also been received, which cannot be ignored. We will ensure that the justice is not only done, but manifestly seems to be done. Ladies and gentlemen, although the magnitude of the cases cannot be reduced significantly, however, the results are encouraging and we are hopeful to make a breakthrough. District courts have much significance. They are flooded with cases. The main reason is population, growth and increasing public confidence in the administration of justice, because of which fresh institution of cases is gradually increasing. And why not? After all, it is the right of every citizen to enjoy his fundamental rights and file a suit or complaint if he is deprived of his right, so that his life, honor and property are secured. In Pakistan, different traditions are in vogue based on nationality and race, but individually no one is willing to compromise his right or claim as enshrined in the law or the constitution. This is a good tradition and requirement of modern time, so that every wrong or the grievance is redressed and relief obtained. Indeed, this is warranted by the constitution. The citizens must have the protection of the rights. All these facts reveal that litigation is bound to increase and the judicial system must be strengthened to meet the demand of rising litigation. According to Article 37, Sub-Article D of the Constitution of the Islamic Republic of Pakistan, it is the responsibility of the state to provide inexpensive and expeditious justice. Although many efforts have been made time and again to improve the justice delivery system, but they have not been very fruitful to sufficient. It is essential that all the stakeholders cooperate, including judges, lawyers, litigants, parties and court staff. The National Judicial Policy, I think, is an important development towards expeditious and inexpensive dispensation of justice. An important objective of the National Judicial Policy is to ensure the independence of judiciary so that fair, impartial and expeditious justice may be provided. A comprehensive policy has been made to make the judges independent so that they should perform their duties for which they are appointed without any personal or political influence. The Chief Justices and the judges of the Superior Judiciary have agreed not to accept any executive post, no matter how high the post may be. The Constitution obliges the executive to separate the judiciary from the executive. The policy carries out this objective forward. As a result, many judicial officers were withdrawn from the executive and deputed to perform judicial function. From now onward, if any judicial officer is appointed to perform duty in office other than that of the judiciary, not only such appointment shall be illegal, but he may also be proceeded against by the competent authority as per rules. This measure increased the number of the judges who became available for performing judicial functions. It greatly facilitated in expanding trial proceeding and decreasing backlog and pendency.